May I please, Your Lordship?
Yes.
I beg to mention hearing item number 17, Your Lordship.
Give me the pencil.
I'm mentioning on behalf of Sir N. Mosai, Lordship. If this matter can kindly come up after a week.
Hearing?
Hearing item number 17, Lordship. On behalf of N. Mosai.
What happened to you?
He is not able to come because of some personal difficulties, Lordship.
Okay, on
So if
request made on behalf of NMOG, you will call support petition. Yes, up to 1 week.
Obliged, Lordship.
Please, Your Lordship. Your Lordship, I beg to mention item 18 to 26, Your Lordship. These are analogous method. Here, the petitioner is seeking for minimum scale of pay, Your Lordship. And the government has set up a committee to look in the matters regarding this. So,
It's already a settled position of law.
yes, Your Lordship, but since the government is taking a decision, Your Lordship, it may be listed after 3 weeks, Your Lordship.
Yes.
Lordship, I'm appearing on behalf of the petitioners.
I've taken the concern of the senior counsel, Your Lordship.
This was done in February, isn't it?
Yes, Your Lordship, and
Then-
Your Lordship, because of the elections, Your Lordship, MCC was imposed, that's why this could not be taken up, Your Lordship.
MCC has got nothing to do with the committee sitting. Okay. Third, MS,
Berta Tep.
your name is not here.
I'm appearing on behalf of my senior, Lordship. He's
Okay,
in law,
write your name and give it.
Lordship. Yes.
MS,
Inaholi, Your Lordship.
Inauli Leonard. You're a government advocate.
Yes, Your Lordship.
Leonard, government advocate. Submits that the Department of Personnel and Administrative Reforms, Nagaland, has issued a notification dated 16 February 2024, constituting a committee to work out various options and to suggest a suitable policy for regulating remuneration and terms of service of the contingency and fixed pay employees. Stop. She submits that the committee is presently taking up the matter and prays for 3 weeks' time to enable her to receive instructions. Stop. Para, the prayer for adjournment is not objected to by the Learned Council of Education. Accordingly, list up to 3 weeks.
Yeah, please, Your Lordship. I also beg to mention item 29, Your Lordship, on behalf of my colleague Livika, Your Lordship. She's indisposed. So this may kindly be listed after 3 weeks, Your Lordship.
Yes,
I have no objection.
your name,
Mane Konyak.
but I'm Konyak Learned Council for the petition. On request made on behalf of MS
Livika, Your Lordship.
Learning Government Advocate, please the matter after
3 weeks, Your Lordship.
3 weeks.
Your Lordship, if I may, I also beg to mention item 15 and 16, Your Lordship, on behalf of Livika, Your Lordship. In item 16, she has already filed. In item 15, he's yet to file. So kindly grant 4 weeks' time, Your Lordship, to file.
Let it reach,
Okay, Your Lordship.
you will see, let it reach.
Please, Your Worship. I have item 9, 10, 11, 12, 13, and 14, admission.
Let it reach. Let it
May I beg that?
Let it reach. Let the matter reach.
Okay.
May I please, Your Lordship? Lordship, I beg to mention item number 30,
1, 3,
30.
3.
For the respondent number 4.
Hmm.
I pray that the matter may be adjourned for 2 weeks, Your Lordship.
Yes,
No objection.
your name,
Nang sangaya.
Hmm?
Nang sangaya.
Hart Nong Sangayo.
Lordship, I'm appealing for the private respondents. Lordship, there's urgency that may be fixed after 2 weeks. On 25th, Lordship.
Hart Nong Sangayo, Learning Council for the petition. On request made by Mr.
I, Jamir.
I, Jamil, Learned Council for the respond number
4.
4. No, cancel it. Mr. I, Jamil, Learned Council for the respond number 4. Press for adjournment of the matter. By,
Lordship, on 25th, Lordship.
what is
Uh, 2 weeks, exactly. 2 weeks.
for 2 weeks? Stop. Mr. Wati Jamil, Learned Council for the respond number
5 to 9, Lordship.
5 to 9 expresses urgency in the matter.
Lordship, interim order may be continued.
Accordingly, list the matter on 25th of June. Interim order possible to continue till the next September.
Obliged. Keep obliged.
God bless Lordship. Lordship, I beg to mention item 28.
Hmm.
I'm for the petitioner. Lordship, I received the additional affidavit filed by the state respondent this morning.
Hmm.
So may I be that this may be listed next week.
Okay, Mr. Wati Jamil on the council for the petition. Submits that he has received the additional affidavit filed by the state respondents
Yes, Lordship.
only this morning. And prays for adjournment of the matter by 1 week. Praise Allah, list up to 1 week.
Lordship.
May I please, Your Lordship, I beg to mention item number 27 on behalf of Taga Kichu. The main counsel couldn't turn up, my lord, due to his difficulty, ill health. Your Lordship, may kindly be pleased to list this matter on 28th June.
Okay, on request made on behalf of Mr. Takakichi and the council for petition, list the matter on 28th June. Pleasure.
For admission,
Your
item
Lordship,
number 1.
Like to mention for item hearing number, item number 33. Your Lordship, here, the leading counsel has some personal difficulty to take up the hearing matter today. Kindly list the matter after 2 weeks.
Who's the leading counsel?
Kikri Senior.
Okay, I'll make the request made on behalf of Ms. Christian, leading counsel for the petition. Yes, 2 weeks.
For admission, item number 1.
My pleasure, Lordship. Lordship, in pursuit of the court order, I've already filed my affidavit. So Lordship, you can list this matter for hearing.
Additional affidavit.
Lordship,
Yes. What are you saying in your additional affidavit?
Lordship, as per court order edit 3/2024, I was instructed to put these two documents on record. And accordingly, I have placed the record by way of affidavit.
This is regarding the reservation.
Lordship,
Yes.
Let it come up for hearing.
This is the commissioner appointment
Yes, ma'am.
after 16 years.
Yes.
There's no more commissioner appointment, I think, for you. $16 years, the very object of commissioner appointment is no more. Now. Okay, you want it for hearing.
Lordship,
Learned counsel for the party submits that pleadings are complete. Accordingly, issue rule. As all parties are represented, no formal steps are required. List the matter for hearing in usual course.
on your pledge.
For admission, item number 2.
Please, Your Lordship.
Yeah.
Lordship, here the pleadings are complete, Lordship, and it has come up for admission hearing, Lordship. However, Lordship, I have some difficulties today. So if it can come up after 2 weeks, Lordship. I'm preparing for respond number 6 here, Lordship.
Yeah, M. Kongya.
Yes, ma'am.
Third M. Kongya, learned counsel for the petitioner, on request made by Ms. Lucino, learned counsel for the respond number 6. When do you want?
Lordship, after 2 weeks, Lordship.
List after 2 weeks.
Obliged, Lordship.
Bless, ma'am.
For admission, item numbers 3 to 6.
Your Lordship, here item number 3, 4, and 6, here pleadings are complete. But with respect to item number 5, we are yet to file a reply. Kindly grant us 2 weeks time to file a reply with item number 5.
Last occasion, you also, you were given time.
Yes, Lordship, but we got received instruction later this way. Kindly grant us 2 weeks time.
Okay, MS,
If you come on, please.
this one, no.
Yes, Lordship.
You write your name and give it to
Okay.
learned
Oh.
counsel for the petitioner. Praise for,
On behalf of Kikri Senior, 2 weeks time.
learned counsel appearing on behalf of MS Christopher, learned counsel for the petitioner, praise for 2 weeks time. To file a gender affidavit in WBC number 166 of 2022. Praise the Lord. List after 2 weeks.
Much obliged.
Obliged, Lordship.
For admission, item number 8.
7.
Sorry, item number 7.
May I please, Your Lordship, I beg to mention on behalf of Subhumati, I pray that I may be allowed to withdraw the case with liberty to file afresh.
Why? Why do you want to? You have no case. Okay. MS. Your good name, please. Madam, your good name.
Sorry, Your
Your
Lordship.
good name, please.
These 6 moments, sir.
You write it in learned counsel. appearing on behalf of Mr. Sukumalin.
Yes, your lordship.
Learned counsel for the petitioner, press for withdrawal of this writ petition with liberty to file afresh. Who appears for the state? MS Inaoli, learned governor advocate, appears for the state respondents. With petition is dismissed on withdrawal. With liberty as paid.
For admission, item number 8.
My lord, may I be given 3 weeks' time to file a reply to the counter filed by the respondents 2 and 3?
2 and 3, no? 2 and 3 are the state.
No, my lord.
No, lordship.
Okay,
The
okay, they are
valid
the men respondents.
Yes, ma'am.
We are appealing for the 2 and
Yes, 2 and 3.
Mr. A. Zimomi, learned counsel for petitioner. Is allowed 2 weeks' time to file reply affidavit to the affidavit in opposition filed by the respondents to it. Please come.
Much obliged.
Yes, lordship.
Item numbers 9 to 14.
My lord, I've received instruction only yesterday. Therefore, I may be granted 2 weeks' time for preparation of affidavit and for waiting.
State wants to file.
Mr. A. Zimomi, learned counsel for the petitioner. Also had Mr. Cindy Yamal, learned counsel for the respondents. 1, 2, 3.
and 3.
Stop. Mr. L. T. Santam, learned additional agent available. Submits that he has received instructions and prays for
2 weeks' time, my
2
lord,
weeks' time to file contract with it.
for all the respondent number 4 to 8.
There is a lot. List after 2 weeks.
Much obliged.
For orders, item numbers 15 and 16.
Yeah, please, your lordship. This is the third round of litigation. The first writ petition was filed seeking appointment on the basis of landowner in the Soap District Industry Center, Mangolamba. The petitioner is one of the landowners. Now, during the pendency of the writ petition, another person was appointed. So we were compelled to challenge that appointment. By filing counter, the government came with a plea that the said appointment was made on compassionate ground. The private respondent also entered appearance and they have taken the same ground. So we considered to that, yes, although we are claiming appointment on the basis of landowner, but then since it is appointed on the compassionate ground, we did not have any objection because of the fact that in the meantime, another vacancy arose. So we made a prayer that, look, there is already an existing vacancy, so I may be considered in that vacancy. So with that hope, we have withdrawn the second writ petition, whereby we have challenged the appointment of the private respondent. But the government came with a plea that this is appointed under compassionate ground. So we withdrew that case. And by filing affidavit in reply, we pointed out to the government that there is already an existing vacancy due to the date of one Nangshimaya in the same office. So my case may be considered in that against that vacancy. That was the prayer we have made. And then we have pointed out to the government, taking advantage of our innocence, the government has again appointed another person which is impugned in this present writ petition. So second chance also happened tonight. Now, when the private respondent applied for a post, he applied on compassionate ground. But Lordship is well aware, for appointment on compassionate ground, conditions are there. He is a nephew of the deceased person. So he is not covered by compassionate appointment. Surprisingly and interestingly, when the government approve his case, the concerned MLA has forwarded the application of the private respondent. And when the government approved for his appointment, it was clearly mentioned that appointment approval is on the basis of landowner, whereas he is also not the landowner. So on two counts, both either on the compassionate appointment, he is not coming, and he's also not a landowner. Therefore, on the land ownership basis also, he doesn't have any right. So, but he has been appointed. So we challenge the appointment of the private respondent in the present writ petition, Lordship. That is the issue. So by ignoring my case in two successive opportunities when the petitioner got, it was denied, and then they went ahead with the appointment one after another. So if this kind of orders are not interfered by this honorable court, a wrong impression will be developed and said that you need not go to court, better approach the government and then obtain a favorable order. It is not necessary to go to court. Therefore, Lordship, on the last occasion when the writ petition was moved, notice was issued. It appears that the private respondent has not entered appearance, but
See, the first writ petition, this is 1/76 of 2024.
Lordship,
In this, you are challenging the approval of the government,
approval as well as appointment.
seeking for approval.
Yes,
In the next writ petition, you are challenging the appointment of the private respondent.
correct. That
In the other.
earlier writ petition, that is WPC number 162, I believe.
76. WBC 76.
That is the present writ petition, Lordship.
There the administrative approval is under challenge.
Yes,
Now the administrative approval, was there a stay in this? No stay.
no stay. That is why on the last occasion, interim shall be considered on the next returnable date, and that is today, Lordship. So today it has come up for consideration of the interim prayer, and I have prayed for suspension of the government approval as well as
No,
the
but
appointment.
Then the private respondent has already been given appointment.
Yes,
So there's no point in
no, Lordship.
Saying the
If-
approval order.
If, even if the appointment is issued, if it is illegally issued, then definitely this honorable court can interfere.
Approval is already given. Approval is given.
Yes,
If pending approval, if a stay was there, that's a definition. But then after the approval, appointment is made. So now you have to challenge the appointment,
Lordship.
which you have rightly done in the second writ
with
petition.
due respect, I would not agree with that proposition, Lordship, because if any order is passed conferring some rights on any person, just because the order has been issued, since the order has already been issued, we cannot interfere. If that is the principle, then where the litigants will go?
No. It's not that. Once the appointment is made, we'll have to consider the appointment.
The
whether it is-
primary
whether it is
consideration,
legally done or
Lordship,
not.
in my respectful submission, the primary consideration should be whether it is illegal or not. If not illegal, then no interference.
So that's why
If it is illegal, then it has to be interfered.
appointment is already made.
Yes,
So once appointment is made, we'll have to consider whether the approval is legal or illegal.
pending return of that, consideration of that, Lordship can interfere
On the basis of approval.
as an
already-
interim measure.
Already appointment order is issued. There's no point in staying the approval order.
If,
There's no point in staying the approval order. In fact, your prayer is becoming infructuous.
no, Lordship. When, so long as, because in order to consider the interim, three considerations I must fulfill. Prima facie case, irreparable loss and injury, balance of convenience. What irreparable loss and injury will cause to the private respondent by obtaining an illegal order? But It is at the course of the petitioner. The order has been issued.
we'll
So
have
the
to-
balance of convenience is in favor of the writ
we'll have to
petitioner.
Consider whether the appointment is valid or not.
No, for that notice has already been gone.
So today the notice has come back or not?
No, not yet, in respect of the private respondent, Lordship.
In the first writ,
Yes.
in the
First,
second,
at the time of motion, it was on 13/5/2024.
Oh, this is 76 of 2024.
Yes,
And the other one is 2020.
yes. That has been withdrawn. 162.
No, 129.
129 has been withdrawn, but 2021 is still surviving. For the last 4 years, I'm waiting, but the government is going on one after another appointing.
No, today 129 is listed.
129 is the first writ petition where I have sought for consideration of my case.
That means
162 has been withdrawn.
76 approval is given.
Yes,
Appointment not yet made.
given. Appointment is enclosed as at page 40, Lordship will find.
Of WBC 76.
Yes. It is on 14th of March 2024. I am challenging the approval as well as the appointment.
And the other one?
Other one is
129.
129 is pending.
Does it still survive?
Yes,
129 of
Yes.
2020.
yes. It is to consider the representation of the writ petitioner. That is not considered yet. And from time to time, they are making appointment by ignoring the rights of the landowners. That is how I am before this honorable court, Lordship. And Lordship will find the application at page 36. Application is on compassionate ground. The second paragraph, it is clearly mentioned at page 36. And in page 38, forwarding to the government, the directorate has the government has made a categorical mention that the approval is on the basis of land owner.
Where is it mentioned?
Page
38.
38, Lordship. First line. I am directed to refer to your letter number so and so, stroke land owner. And the private respondent doesn't come under compassionate appointment as well as the landowner.
Okay, state.
I have no idea. Same thing.
On behalf of the legal Lordship, can it is dispatched after 2 weeks? Since my colleague is not present today.
Livika.
Lordship.
Livika has accepted notice on behalf of the state. Lordship.
How about the notice on the response 6?
It was gone, but it has not returned as it appears from the office note, Lordship.
Okay. Heard Mr. Siti Jamal, Learned Senior Counsel, assisted by Ms.
Asarutsa.
Asarutsa, Learned Counsel for the petition. On request, Madam, we have a Ms. Livika,
Lordship,
Learned Government Advocate. List the matter after 2 weeks. In the meantime, our service report on the respondent 6.
Lordship, in that case, the appointment of the private respondent shall be subject to the final outcome of the
Appointment
case.
of the respondent 6 shall be subject to the outcome of this report.
I oblige.
For hearing, item number 31.
Who's on the other side?
Miss IMA is representing the state.
Yes. Caller.
Lordship, this matter pertains to claim for appointment on land on the basis of land ownership. The petition, 3 families, including the petitioner's family, donated a plot of land for setting up medical sub-center at Ongor village. One candidate from one of the families has been appointed. The 2 families are yet to be appointed. That is my case, Your Lordship. In 2021, a vacancy arose at the sub-center of the post of medical attendant. Petitioner submitted a representation for consideration of her case against the said post. However, on the basis of land ownership. However, without considering her case, the case of the private respondent was approved by the government. And
yes,
Lordship, AIM is engaged before the Honorable Court number 3. So can we discuss this matter after some time?
You want to take up after some time?
Yes, he's engaged before number 3.
For hearing, item number 32.
I'm ready, my lord. My junior, Mr. Imti Longjam, he had a vehicle breakdown. He's about to reach. In the meantime, maybe the other matter can be taken up.
For hearing, item number 34.
One of the petition is the petitioner applied for certain document by Annexure 1, page 23 to the BIO Agriculture Production Commissioner. The documents is the RDA.
Who is on the other side?
I'm for number 2,
You're for?
the State Information Commission.
Information
Okay,
Commission.
Okay. And any other degree, director, state?
Government.
Is Mary accepted notice?
One, 3, 4, 5. See something.
Yes.
So, my lord, the application is based on.
Why
the-
are these respondents 6, 7, and 8 by person?
My lord, they are directly involved in the proceeding. But however, this honorable court decided that they needn't be made the party respondent on the first day. So I've accepted that. So only the government side.
So
that
their
is-
names have been deleted.
My lord, it is not.
Notice was not sent.
No. Was the decision of this honorable court. So, my lord, I applied for the documents referring to page 24. What happened is this. Agri Department, this is 5th March 2021. In pursuance of the decision taken during the consultative meeting on the land issue with all DAO office complex OCA held on 04/03/2021 under the chairmanship of the APC. A committee is hereby constituted with following composition. These are the names. 7 of them. The committee will examine all relevant documents and make a report with cadastral survey of the area of land under the dispute and submit a report by 30/4/2021. This is what I sought for. What happened is that no reply was given. The only reply is annexure 2, page 26. With reference to your data such and such, I am directed to furnish you with a reply to information sought under such and such. Query 1, decision taken during the consultative meeting on the land issue such and such under the chairmanship of the APC is included as annexure 1. That is page 27. Minutes of consultative meeting held on such and such. A consultative meeting on the land issue with such and such was held on such and such. It's such and such of EPC as per annexure A. The background of the dispute in report of the APP was discussed at length. And after invitation of citation from the concerned department, the following decisions were arrived at. 1, constitution of a committee headed by the additional secretary, Agri, and members from the Department of Agri, Health and Family Welfare, Horticulture, Water Resource, Land Revenue, and Justice in Law. The committee should constituted to submit its report by such and such. And next is query 2, committee report with all relevant documents in cadastral survey cannot be disclosed. That is what they are saying. Then 3, meeting minutes with attendance sheet. The office does not give report of any informal meetings with the individual in society and organization, etc. Video recording of the meeting. The office does not take video recording of meeting proceeding. The APC chamber has CCTV cameras installed in the office entrance in the conference hall of the security for security purpose only. Decision of the meeting, no official decision were made. Because in this meeting, the petitioner, along with two of the members, they attended the meeting. There was a video recording. And it was headed by the APC, who is an IAS officer, another Mr. Jaiswal, who is an IAS officer, representing the department. Then they are saying that no recording was done, and no minutes were taken. We ourselves will file our attendance in the attendance sheet. That is what I have demanded, which they are saying that no, this is not maintained. For that matter, there is a procedure how to maintain these documents. Page 43. It is 14 September 1976. Instances have come to the notice of the government that in some cases, government servants, while in performance of their official duties, acted under verbal instruction and direction of superior officer without getting a confirmation in writing. This practice is highly irregular in contravention Rule 242, Roman 2 of the Nagaland Government Secretary. Relevant extracts are reproduced below. Rule 34 will be more relevant. Record of verbal discussion, orders and instruction, all points emerging from discussion between two or more officers, and the conclusion reached should be recorded on the file by the officer authorizing action, in where necessary the circumstances leading to such order or instruction. This should be recorded on the file, and in important matters should be confirmed. That is the practice in the secretary. Then, not satisfied with the reply, the petitioner filed Annexure 3.
Annexure?
Annexure 3, page 28. Appeal. Before the first appellate authority. And what happened is that page 32. Furnishing up reply to your such and such. Sir, with reference to your appeal letter, such and such, first appellate authority received by the department dated 16 December, such and such, I am directed to convey that the government stands by its earlier reply by the letter 21st of November 2022. So practically there was no action on the first appeal. Then, my lord, the petitioner approached page 34 to the State Chief Information Commissioner. Then, the petitioner in the other side were invited by Annexure 6, 36. This is the decision. This is the notification. Then decision on the same date, that is 28 April, page 38.
What is the decision of the CRC?
Page 41. On the above observation and findings, the commission decided that a copy of the committee report on the land issue of Old DAO complex, which was submitted to the Agri Department in April 2021, shall be furnished to the applicant, now appellant, with a copy to the commission within 15 days from the date of receipt of this decision. Two, though the committee had given its recommendation, the department has been taking a long time to complete action on the recommendation. Hence, as requested for more time, the department shall complete acting on the recommendation of the committee within 3 months, which might help in resolving the long pending issue. Decision pronounced in presence of both the parties and such and such. Then it appears that the department approached for a modification which was not informed to us. And the order was furnished to us, that is page 44. So, may I read out the whole lot? Modification of the decision of NIC. Whereas after the hearing of the second appeal dated 14/2/2023 and 19/4/2023 at 11 a.m. in presence of both the parties, the commission had passed its decision by even number dated 28/4/2023, which is reproduced as below. That is what the earlier decision which I read out. Then, in whereas on 19/5/2023, the commission had by later dated 8/5/2023 received from Sri Zakabu Sajin Deputy Secretary in BIO Agri Department, Nagaland, Kohima, requesting for modification of point number 1 of the above decision of the commission dated 28/4/2023, stating that the committee's report being confidential in nature for the department is of the opinion that it may hamper the department in the government at large, and it will be very premature to furnish the committee's report to the appellant before a decision on the matter is taken by the government. Therefore, request to modify para 1 of the decision dated such and such in order to let the government take action on the committee's report. First, upon which the report of the committee will be submitted within 3 months' time. In whereas the commission, after examination of the above request for modification of its order, accepted the above request and that instead of furnishing the committee report to the applicant, now appellant, within 15 days from the date of receipt of the decision, the committee report shall now be furnished only after the government decide on the recommendation of the committee, in which 3 months time was given to the department as decided. Decision with number 2 of the commission, decision dated 28/4/2023. Now, therefore, the commission decided that the committee report shall be furnished. That is very clear to the applicant only after the government take this action on the recommendations of the committee, for which 3 months time was allowed as requested. So it is an extension of time. So by page 46, it was intimated about the modification by the commission, which then what happened is this. Annexure 10A, page 48. You were always all along saying that we'll furnish it to you. That is the NIC order. Subsequently, they asked for 3 months' time. It was given. Even though the petitioner was not heard, we were under impression that the department is going to furnish it after the said extended period. Instead of that, what happened is this. This is 30th June 2023. Minutes of the meeting to discuss on the land issue with all the office, OCA held on 23/6/2023 at 1 p.m. in the conference room of the Chief Secretary under the chairmanship of the Chief Secretary Nakal. A meeting to discuss on the land issue with all the office, OCA was held on 23/6/2023 at 1 p.m. under the chairmanship of Chief Secretary Sri Sajin Saj. The meeting was attended by Department of Horticulture, Health and Family Welfare, Water Resources, and Commissioner Nagaland, along with DEC OCA meeting attendance. The chairman requested the Commissioner and Secretary of Agriculture to brief about the issues before the House for deliberation. The Commissioner and Secretary in the additional Chief Secretary of Agriculture briefed the House about the issues of compensation sought by that is the petitioner, and illegal encroachment of area, public office, public quarter of agriculture, horticulture, health and family welfare, in water resources department by various private parties in the ODO office area in Oka, and also brief on the hearing called by the Chief Information Commissioner of Nagaland, where the Department of Agriculture was directed to take another committee report on the land issue with ODO office area Oka and furnish the same within 3 months, that is 2nd of August 2023, being the end of 3 months. So all the department concerned were allowed to present their issues, and after taking into consideration the inputs, suggestions, recommendations, and the matter given by the members present, the following decisions were made. One is to set aside the earlier committee report and set up a new committee on land issue at ODO office OCA. To thoroughly look into the matter, the committee members will be the same as before, as those committee members constituted before. Only the retired member to be replaced. In view of the severity of the issue, the committees who constituted shall be classified as confidential. In all matters in files in this regard shall also be marked confidential. The committees who constituted will submit its report within 3 months from the date of setting up of the new committee. 2. The matter of land issue at ODO office area OCA, which shall be placed before the advisor and minister in charge, along with report of the above said committee. To write to the Chief Information Commissioner Nagaland, Information Commission NIC, stating that the government is in consideration of the case in according to the set up a new committee. The meeting ended with a note of thanks from the chair with the request to seriously look into the case and to defend and protect all the government properties. My lord, the matter is already settled. Before the State Information Commission that yes, we are going to furnish the report.
Before the Information Commission, they said that they'll take a decision and submit a report.
Yes.
So decision is there, whereby they decided not to act on the committee report. and set up a new committee.
No.
The same old committee, but the retired members are to be replaced.
Yes.
And they have to take a decision. Let us see the commission's order that.
Page 41.
Page 41.
It starts from 38. If I may be up there is okay. If I may be allowed to start from page 40. Observations and findings. The commission had on 18/4/2023 received a letter by such and such dated 17/4/2023 from the Agri Department, Nagaland, Kohima, informing that the first appellate such and such IS Agri Production Commissioner in Director General ATA Nagaland, Kohima would not be able to appear for the hearing on account of a meeting with IFAC officials regarding focus project along with state project director in Delhi and such and such. A copy of his store diary was also included. However, Sri Akam Jamir, advocate in department's legal consultant, was authorized to appear on his behalf. During the hearing, Sri such and such legal consultant for the applicant, now appellant, stated that the land of the applicant, now appellant, Sri such and such, was occupied by the government. A meeting was held on 4/3/2021 in Oka under the chairmanship of Agriculture Protection Commissioner hereafter APC, wherein a committee was constituted. In report to be submitted by 30/4/2021. Another meeting was convened on 27/9/2021 from 12 noon to 2:05 p.m. An attendance sheet in video recording were taken. However, neither the committee report nor the outcome of the meeting was made known or received till date. Regarding query number 1, the applicant had sought for the decision taken during the consultative meeting on the land issue at ODEO office complex, Oka, held on 04/03/2021 under the chairmanship of APC, as clearly stated in the office notification dated 5/3/2021 in had inclusive copy, that is in the first RDI application. In the reply given by Srimati Sajin Sach, Under Secretary in APIO 3 Department, Nagaland, Kohima, by later Sajin Sach, a copy of minutes of consultation meeting held on 4/3/2021 by Sajin Sach 9/3/2021 was included, wherein the following decisions were arrived. 1. Constitution of a committee headed by the Additional Secretary Agri in members from the Department of Agri in Health and Family Welfare, Horticulture, Water Resources, Land Revenue, and Justice in Law. The committee so constituted to submit its report by 10/4/2021. The commission observed that information had been furnished since a decision to constitute the committee and submit report by 30/4/2021 is also a decision of the constitutive meeting held on 4/3/2021. Hence, no further direction is required. Regarding query number 2, on being asked by the commission whether the committee had submitted its report as decided in the consultation meeting held at 4/3/2021, Sri Akam Jamia, advocate and legal consultant for APC in FAA informed that the final report of the committee on land issue in all the office complex, UCA, was submitted, my lord, to the Agriculture Department in April 2021. In its recommendations are still under active examination and consideration. So the issue is about this report with which the petitioner have applied. So to take a decision or not to take a decision is up to the government. But I just want this particular report. And it was specific for the commission that yes, there is a report to that effect. So the stated that there is a report. And it is under examination and consideration. However, since eviction is involved, that is some illegal occupant, he feared that information cannot be disclosed at this point of time under section such and such. The commission observed that since the final report of the committee was recommendatory in nature, that is what I've asked. I didn't ask for a final decision. It cannot fall under the exemption as there appears no threat or its disclosure would impede any process of investigation. The commission also viewed that cadastral survey is used for proper planning by the government and hence cannot be exempted from the disclosure. The commission also observed that the recommendation of the committee are under examination. It's all right by the department for a long time and hence needed to be expedited to settle or resolve the issue. Regarding query 3, such and such, for the applicant stated that the meeting was attended by one such and such IAS APC along with his base, Mr. such and such Additional Secretary, Agri Department, Mr. such and such IAS Joint Secretary, Agri Department, Mr. such and such Agri Department, 5 in from the applicant, now applicant side, Mr. the petitioner, Srimati such and such, in Sri Chishi. However, translate the WhatsApp message, Sri such and such Deputy Secretary in BIO Agri Department, Nagaland, Kohima, stated that it was on the request of the applicant that the meeting was called. So it is an admitted fact. On 27/09/2021 at 12 noon. And hence, there was no official correspondence by the department in calling the meeting. In no attendance, in no videography were taken. That is their submission.
That was dismissed.
That is one aspect of the matter. But what I am is on the report, final report of the committee.
So that's why the direction was given that shall complete acting on the recommendation of the committee.
I want the recommendation of the copy of the recommendation. That is what the whole issue was that. I didn't ask that there should be a decision to that effect. My application was the recommendation report in the cadastral survey. So the decision is clear that on the above observation and finding, the commission decided that a copy of committee report on the land issue is such and such, which was submitted to the Agri Department in April 2021, shall be furnished to the applicant, now appellate. And with the copy of to the commission within 15 days from the date of receipt of this decision.
Now this page 44. Is it under challenge?
Yes.
We are
Yes,
challenging this. Because here it says, instead of the earlier decision to submit the committee's report within 15 days, here it says that the committee report shall not be furnished only after government decide on the recommendation of the committee. So the recommendation of the committee was rejected. By that modification.
Yes.
Which was done behind your back.
Yes. View it on page 2. Yes.
Is it impugned? This is not impugned.
Yes, only page 48.
Only 48 is impugned.
Yes.
What is wrong in page 48?
48.
They have taken a decision not to accept the recommendation of the committee. And the modification order also clearly provides that the committee report shall now be furnished only after government decides on the recommendation. So government has rejected the recommendation.
My lord, what I am submitting is this. The first report which has been submitted. That is what I sought for. In the commission also directed for furnishing of
That
that.
is what you saw. You filed appeal. Then you came on the second appeal. Second appeal direction was given to submit the committee report within 15 days.
Yes.
And the second part was that the government to take a decision on the recommendation of the
Yes.
commission within 3 months.
That is a different issue.
All right.
Yes.
That's a
That is
different
all right.
After that, they filed a modification order.
Yes.
They filed a modification of the order.
Yes.
By that modification, read it. It says, committee report shall now be furnished only after government decide on the recommendation of the committee within 3 months.
Yes, I understand your lordship.
Supposing you are not happy with this, so now what has happened? Let me tell you.
My lord.
After the modification order was passed, the government took a decision to reject the recommendation of the committee.
That is whether to reject or to take a decision, that is up to the government.
Yes.
But my specific prayer was to furnish me that report.
That report by the modification order has already been, you will have to challenge this modification order.
Yes. That modification order,
Page
which is
44.
30th June 2023, I have challenged before your lordship.
No. 22nd May 2023. It's page 44. That we have to challenge. Unless you challenge this, nothing survives.
My lord, if I may be submitted in this manner, it is a communication only the modification of the order. Modification of the order of the earlier decision shall be furnished to the applicant now only after the government take action on the recommendation of the committee for which 3 months time was allowed as requested.
The commission in the second appeal,
My lord.
by the modification order, directed that the government shall take a decision on the recommendation of the committee.
My lord, what I'm
Within
saying.
3 months.
Yes,
Alright.
my lord.
So that is the final order.
My lord, that is the decision of the commission, not on my application. You have taken your own decision, which is not my.
You're not agreed with this. You're not agreed with this.
I didn't asked for taking a decision. Of course, the commission can pass an order, whatever is deemed fit.
You were present in the second appeal. When the second appeal was disposed,
Yes,
you were present. Correct,
yes,
correct. With that order, you are happy because you have been directed to give the committee's report within 15 days.
yes,
So you are happy with that.
my lord.
You are happy with that. After that, the government, again, the department came up with an application begging for modification of that particular direction. And that direction was modified, saying that the committee report will now be furnished to you only after the government takes a decision on the recommendation within 3 months.
What I managed is, okay. The first order is specific that I should be furnished with the committee report. That is the commission.
That's why you were not given the report. You went on appeal. There also you were not given. Second appeal, you went.
My lord.
Correct.
My lord.
There, the decision was given for furnished within 15 days.
My lord.
Fine. After that, they filed an application for modification of the particular direction, and that direction was modified. So unless you are impugning that modification order, what is wrong with the government taking a decision not to act on the recommendation of the committee?
My lord, if I'm not mistaken, they have given only extension of time to 3 months instead of 15
Read the
days.
order, read the order. Page 44, last paragraph. That is the direction. Read it properly.
Yes, my lord. I may be given some time so that I can file another supplementary writ. This I was not aware.
You can't file a supplementary. You'll have to file an amendment. You'll have to file an IA for amendment of the.
My lord,
petition.
I may be allowed to do that. For an amendment application,
At the hearing stage.
my lord. My lord, to be honest, I was concerned about only the committee report. The other part, what the commission has decided, that was not my prayer. It have nothing to comment on that.
Your submission is government constituted the committee to look into the issue of the TO's office in Oka. That committee made its recommendation.
Yes,
You wanted a copy of that recommendation.
my lord.
You were not given a copy of that recommendation, saying that the department said it has not, that the government has not taken a decision. Correct, RTI. So you went on appeal. Appeal also same answer came. Second appeal, direction was given that the committee report should be given to you within 15 days. They filed an application for modification. That order was modified. And directing that only after government take a decision, that also within 3 months. Government took a decision rejecting the recommendation of the committee.
So I may be given liberty to approach by withdrawing the present writ.
Okay. Let us be a little liberal. Mr. M.T. Longshard and the council for petition press for withdrawal of this writ petition with liberty to file a press. Mr. Limabang, Leonard Council, appears for the, no, MS, S. Mary, ERD,
Senior government.
Senior Government Advocate, appears for respondents, 1, 3,
3, 4, and 5.
4, and 5, and Mr. Limapa. You're the standing counsel. Learned
NIC.
counsel appears for the
NIC.
respondent number 2. Oblique Nagaland Information Commission. With petitions dismissed on withdrawal with liberty as well.
Much obliged.
For hearing, item number 31.
Ready, my lord.
No, this is not your case. Oh. Yours is 32. 31 is. Oh, 31. Yeah, has come.
No.
Is she coming or not?
Lordship, she's engaged in the court number 3.
Still there, the other court.
Item number 32.
Where's the book?
Paper book is there.
Paper book.
Yes, my lord. That's the people. May I begin, my lord? May I take your lordship first to the judgment in question, which begins at page 20 in my review application. Page 20.
Yes.
Yes. If you may go straight to paragraph 2, my lord, at page 21. Just a few of the initial paragraphs. A dispute arose between the respondent plaintiff village and the appellant's defendant village when the appellant's defendant erected Nemdang below Inak Pond at Zilla River. Objection was raised by the villagers of the respondent plaintiff, and therefore the appellant's defendant villages re-erected Nemdang at Zilla River in the junction of Narapyong Longzuk, encroaching the respondent plaintiff, fishing right in the portion of the said river. As a result, the said Nemdang was destroyed by the villagers of the respondent plaintiff. The dispute is with regard to the fishing right in the river between Surayong Longzuk and Narapyong Longzuk. The dispute was tried by the Dubashi's court, Mokokchung, which was registered as case number 345 between the respondent plaintiff and the appellant's defendant. The DB's court disposed of the matter on 25/11/2001, holding that the boundaries between the parties shall be the Narap-Dikkur River confluence. Being aggrieved, the respondent's plaintiff filed an appeal before the court of the learned additional deputy commissioner judicial, Mokokchung, which was registered as civil appeal number 3 of 2001. In the appeal, the respondent plaintiff also prayed for a de novo trial. On 9/8/2002, the learned court below, in the presence of the counsels for both the parties. So, Your Lordship, we'll stop at paragraph 3 now. So a de novo trial was ordered. Now, with that in mind, can I take a watch? And the appeal filed by the respondent in this case, the appellant, before the learned ADCJ, Mokokchung. The page number 1, Your Lordship. Now, Your Lordship, may I stress again, a de novo trial. And this is the appeal which was filed under Rule 31 by the respondents as the appellants. May I read, my lord? It is just paragraph 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. The grounds, paragraph 10 is the grounds of appeal against the decision of the Dubashi's court. And finally, Your Lordship.
1 minute. Why all these blue sheets?
Another copy of the paperwork.
The second copy. These are all blue sheets.
You have an extra copy of the paperwork? Yeah.
1 minute. Get a clip or something like. Get the clip. It's okay. I'll get a clip.
Hello.
Tell them to stitch it up.
Page 7, Your Lordship. Page 7. And paragraph 11.
Yes.
Paragraph 11, that this appeal is filed bona fide and in the interest of civil justice. The prayer, my lord. In the premises aforesaid, it is displayed that the honor may be pleased to admit this appeal, call for the records, and may please be served notice to the opposite party showing cause as divide the judgment order dated 25/1/2001. But that is the Dubash's court, Your Lordship. Pending disposal of this appeal, Your Honor may be pleased to stay the operation of the said judgment, impugned judgment and order dated 25/1/2001, passed by the Dubash's court for Kukshon. So after the de novo trial was ordered, this is what remained. This is what remained. On this basis, the trial proceeded. The first point I would like to make, on this basis, the trial proceeded. So whatever was decided in the learned trial court should have been based on this. There was no amendment. There was no amendment to the plaint. This should have been treated as a plaint, or the appellant respondent should have been asked to file a plaint with proper pleadings, with the proper prayers. Nothing. This was treated as a plaint. And on the basis of this plaint, evidence was led. Evidence was led, which is not a part of the pleadings.
No, but was this ground taken when the appeal was taken?
Where, my lord?
Was this ground taken when the appeal was taken?
No, my lord, but this is a point of law, my lord. This is a point of law. And this is an error apparent on the face of the record, Your Lordship, even before the learned trial court. An error of law apparent on the face of the records. So there was no proper pleadings. There was no prayer of any sort. On the basis of this, pleadings, the learned trial court could not have decided in favor of the respondents. Could not have decided in favor of the respondents. That is the first point I would like to make. And on the issues on the principles and the principles of law, that I will place authorities before. Now, the second point which I wish to make now. Why?
So, 1 minute. Your first point is?
First point is on the basis of the pleadings filed by the appellant. No findings could have been arrived at by the learned trial court.
Yes.
Secondly, Your Lordship, related to this. Secondly, evidence could not have been led outside what is stated in this memorandum of appeal.
Yes.
Thirdly, my lord, there are no prayers in this memo of appeal. Evidence could not have been led outside pleadings. Therefore, my lord, there was no pleaded cause of action for the learned trial court to proceed in the de novo trial. Cause of action has to be pleaded, Your Lordship. There was no cause of action for the learned trial court to proceed in terms of the pleadings filed. That sums it up, my lord. That sums it up. And having ignored that, that is an error of law apparent on the face of the records. That is the first point I'm trying to make, Your Lordship. The second point now, Your Lordship, if you can go back to your memorandum of appeal. And the deliberations in this from paragraph, page 27, my lord, page 27. Page 27.
Yes.
Paragraph 11. Paragraph 10 is, of course, your lordship's record of the submissions, consideration of the submissions, and 11. A consideration of the LCR's projects that on 24/10/2002, the loan issue was framed on consensus of both the parties. Therefore, this court is of the considered opinion that the submission of the learned senior counsel appearing for the appellant that the issue was wrongly framed cannot be accepted. Further, with regard to the implement of the government of Nagaland as a necessary party, cannot be accepted at this stage, inasmuch as the said ground was not taken before the learned court below. 12. On a consideration of the submission made, the only issue that is required to be determined in this appeal is with regard to the fishing right between the Surayong Longzuk and Narapyong Longzuk at Sila River. To decide this issue, the evidence of the PWs and DWs requires to be appreciated. PW1 stated that the plaintiff village has fishing right from Surayong Longzuk to Minsungyang at Dukh River. The said portion of the river is being enjoyed for about 16 generations and no other villages interfere with the right. The said portion of the river is jointly enjoyed by both Yacham village and the plaintiff village. In the year 1961, 1996, 1918, 1991, villages of the plaintiff poisoned the Dukh River from Surayong Longzuk to Narap stream and from Narap to Menam Tsuyong. In this community fishing, they have invited by way of Anja the following villages: A. Yongyimson, Changtongya, Chuchuyumlang, Yongyimchen, and Yacham. He has also stated that one Imliwati and Imlitimjan have poisoned the Dukh River between the portion of the disputing fishing right by using bleaching powder, and as a result, the plaintiff village council tried the case, and on admission of guilt, Imtiwati and Imlitimjan was fined ₹500, and the said money was shared with the Yacham village council. He has stated that the village acquired the land up to Longjara village, Longjara, which is located upstream of Surayong, and from Longjara to Narab stream on the bank of Dukh River, which was acquired by individuals and sold it to individuals of the defendant's village. From Longjara to Narab, the landed property was sold by one Nangshilimba of plaintiff village to one Minjakam of the defendant's village. The land located between Narab and Losang stream was acquired by one Metong Sangba of the plaintiff village after establishment of the plaintiff village, and one of his descendants sold it to Imkonglimba of the defendant village. And today, all these lands have been purchased by and possessed by individuals of the plaintiff village. The land located between Longchara and Narab belonged to individuals, and by selling it away, fishing right of the plaintiff village located between Surayong and Narayong was not extinguished because fishing right between the said portion was acquired by the plaintiff village. Now, Your Lordship, as far as this witness is concerned, there are other statements of other witnesses who contradict this statement. But what has happened, may I most respectfully submit, my lord, is that only one side of the story has been considered. The other side has not been considered. And there are contradictions even from their own witnesses as far as this statement is concerned. All that is on record. Then 15, PW2 stated that he was one of the council members from 1982 to 85. Misunderstanding arose among the council members of plaintiff village, and consequent upon it, the deputy commissioner Mkokchung dissolved the council in the month of November 1985, but they maintained themselves as council members up to the year 1988. After the dissolution of the council, another council was formed at the plaintiff village by 5 members, while under such circumstances, the Dukh River water dispute arose between the defendant village and Ungar village, which was tried by the Mkokchung DB's court. In the said case, they have also testified on 16/6/1986 that when community fishing was performed by Ungar village, they also went and attended the community fishing. Further, 5 members also testified in favor of the defendant's village. This also, Your Lordship, again, my most respectful submission is that this is only one side of the story. Then 16, PW3 is one Mr. Imlitamjun who was imposed a fine of ₹500 by the plaintiff's village. In his deposition, he stated that once Imliwati and himself were caught by the plaintiff's counsel for poisoning Dukh River between Narab and Surayong, and they admitted their guilt and were fined ₹500 by the plaintiff village because the plaintiff village is the co-owner of the Dukh River between the portion of Narab and Surayong with Yacham village. Same thing, Your Lordship. Yeah, 17. PW4 stated that the land located between Longchara and Narab stream was first acquired by the ancestors of Changtongwonen after the establishment of the plaintiff village. The said portion of land was sold by one Nangshilemba, a descendant of Chandang Onan to 1 Mejakam of the defendant village. He stated that the personal property of the land situated on the bank of Dikhu River between Longchara and Narapyong was sold, but the fishing right located between Surayong to Narapyong was not sold because fishing right was acquired by the plaintiff village. Same thing, Your Lordship, it's just one side of the story. And PW 18. PW 6 is a citizen of the Yong Yimsen village representing the Yong Yimsen Village Council. He stated that his villages were invited by the plaintiff village whenever they performed fishing at Dikhu River in the year 1966 and 1991. He had attended community fishing at Dikhu River. During those years, community fishing by the plaintiff village was from Surayong Junction to Dikhu River. The Yong Yimsen villagers gave a sum of ₹10 as a mark of acceptance of Anja to the plaintiff village during that day. In the community fishing, the plaintiff villages invited Yong Yimsen village, Chongtongya village, and Yacham village, since they are neighboring villages of the plaintiff village. Same proposition here also, Your Lordship. 19. PW7 is a village council member from the Chongtongya village. He stated that whenever the plaintiff village performed community fishing at Dikhu River, they used to invite Anja, Chongtongya villages. He was also present while performing community fishing at Dikhu River by the plaintiff village and poisoned the river from the junction of Surayong to the downstream of Menang Struyong at Dikhu River in the year 1991. He stated that Narap stream is situated in the downstream of Surayong at Dikhu River. In the year 1991, he stated that he was also present as an invitee as he paid ₹10 to the plaintiff village as a token of acceptance of Anja. Now, Your Lordship, again, this is only one side of the story, but all these the statements of all these witnesses are only to the effect that they participated in fishing in the disputed area. That is all, Your Lordship. Now, the other side of the story is our witnesses, including their witnesses, also say we also participated in the fishing in this disputed area. So can just merely participating in the fishing in this disputed area lead to a conclusion that the ownership of fishing rights belongs to the appellates or the respondents in this case?
No, that you are entering into minutes.
Yes, my lord. No, my lord. Why I'm saying this is this. Why I'm saying this is this. There are two sides of the story. What has happened in this case, Your Lordship, is that only one side of the story has been taken into account. That is what I'm saying, Your Lordship. Evidence on only one side has been taken into account. The evidence on the other side that we also participated in the fishing in this disputed area in all these years, that has been ignored. That is what I'm saying, my lord. That is the point I'm trying to make. Then 20. PW8, who is from the plaintiff village, stated that they are fishing right from the junction of Surayong at Dikhu River to Mentuyang, including the disputed portion. They have fishing right from the junction of Surayong River at Dikhu River, which was acquired by the plaintiff village after the establishment of the village and enjoying till today. The fishing right dispute between the plaintiff and the defendant from the junction of Surayong and the downstream at Dikhu River does not disturb the fishing right of Yacham village because they did not have any fishing right dispute with Yacham village, and as such, the Yacham village can poison the disputed river at any time. 21. DW1 is the council camp secretary of the defendant village. He stated that the present dispute between the plaintiff and the defendant is for fishing right between the Surayong junction to Narab stream junction in the river Dikhu. There is no fishing right on the stated portion because the plaintiff has no land on both banks of the disputed portion. In point of fact, the Ao Naga custom and tradition is that fishing right and land go together and refer to the book Ao Naga customary law written by Mr. Tajanao. Whereas in the instant case, the plaintiff has no land on the said portion. He also stated that the portion from the Surayong to Narab stream junction, the Yacham and the defendant village are the co-owner of the fishing right, as the land on the banks belong to the two villages and the plaintiff has no land at all within the disputed portion of the river. The appellant villages never poisoned for fishing within the disputed portion. Now, Your Lordship, this is DW1. This witness's statement remains unimpeached. This witness's statement remains unimpeached. As far as the plaintiff's witnesses are concerned, one side of the story. The other side of the story, that we are also engaged in fishing in this disputed portion, that has been ignored. DW1's statement is unimpeached. You have no fishing rights. Land and fishing rights go together. This is the only piece of evidence which is unimpeached, my lord. 21. Then 22. DW2 is a village council member from Salulemang. He stated that he has attended the community fishing on 2 occasions, that is, in 1976, while the Dikhu River was poisoned from Luwangang to Narab stream junction. The second community fishing was on 29/1/2001, where the Dikhu River portion was poisoned from Subolong to Narapyang junction. Then DWC stated that it was during the winter of 1976 The defendant village invited their villagers during community fishing, which is called as Anja. He also attended for the same community fishing, and the portion of Dikhu River from the Subonglong up to Narab from the stream junction was poisoned for fishing. D55 is the secretary representing the Yasham Village Council. He stated that in the recent years, both the defendant and the plaintiff came to the village stating that for land dispute, a case has been registered in the court of law. Their village council tried for reconciliation among the parties of the dispute and to live peacefully, but they could not manage to bring them together for settlement. 25. A consideration of the deposition of PW1, 3, and 5 will indicate that PW3 and PW5 were caught by the plaintiff village council for poisoning the Dikhu River between Narapyang to Surapyong. They were fined ₹500, and the fine amount was shared between the plaintiff village and the Yasham village. The statement of PW1 indicates that in the year 1961, 66, and 1981, while performing the community fishing, the invitees by way of Anja were Yaung Yimson, Chongtongya, Tuchimlang, defendant village, and Yacham village. The statement of PW1 is corroborated by the statement of PW6, who has stated that in the year 1966 and 1991, he has attended the community fishing of the plaintiff village from Suroyong junction at Dikhu River, and his villages gave a sum of ₹10 as a mark of acceptance of Anja to the respondent village, plaintiff village. The deposition of PW1 also indicates that the land located between Longchara and Narab belongs to individuals who had sold the land between the fishing right of the plaintiff village located between Surayong and Narapyong was not extinguished as the fishing right between the said portion was acquired by the plaintiff village. The statement of PW1 is corroborated by the statement of PW4. Now, Your Lordship, I was earlier saying that the statements must be on the basis of pleadings in the plaint. Any evidence, we cannot go beyond, that is the law, Your Lordship. The evidence you present in court cannot go beyond your pleadings. No such statements at all in the plaint. The memo of appeal, Your Lordship, they had the opportunity to amend it, file a proper plaint with proper pleadings and with proper prayers. They did not do it. All this evidence which has been led by the appellants, respondents here, are not based on the pleadings filed by them. And that is an error apparent on the face of the records, Your Lordship. Then, page 26, Your Lordship. Paragraph 26. The submission of the Learned Senior Council appearing for the appellants that PW3 and PW4 has admitted in their deposition that they have no landed property between Suryong and Narapyong in Dikhu River has also been considered by this court. However, the submission of PW4, who is a citizen of the respondent village, clearly indicates that the land located between Longchara and Narab Singh was first acquired by the ancestor Changtong Onen after the establishment of the respondent village. Now, this is, as far as this statement is concerned, Your Lordship, there is clear evidence on our part that we say, no, they never acquired. We deny that the respondent village acquired any land in this area. That has also not been taken into account. And that statement is unimpeached, Your Lordship. He also stated that the said portion of land was sold by one Mishilimba, a descendant of Changdong Onen, to one Mejakam of the Appellant's village. However, the fishing right between the Surayong to Narapyong was not sold because fishing right was acquired by the respondent village. Again, Your Lordship, may I stress again, Your Lordship, where is the statements, where is the pleading in the plaint that the fishing right was acquired? How was it acquired? Is it mentioned? There's no such statement, Your Lordship. Is it mentioned that the property was bought, but the fishing rights was retained? And how was it retained? No mention at all in the plaint. The statements of PW1 and PW4 that respondent plaintiff had acquired the fishing right over the disputed area could not be controverted by the appellant's defendant. This is not correct, Your Lordship. This is not correct because there is a statement of my witness who says that the land was never acquired. They never bought any land in the disputed portion where the fishing rights are claimed. 27. PW6 is an independent witness from Yaung Yimson village, and he has stated that Yaung Yimson villagers gave ₹10 as a mark of acceptance of Anja to the respondent plaintiff village in the year 1966 and 1981. During the community fishing and the said community fishing, the Yongsam village, Changpyonga village, and Yacham village were invited by the respondent village, plaintiff village. This, Your Lordship, also no basis in the pleadings. No basis in the pleadings. Now, Your Lordship will appreciate in civil suits, what you claim must be specifically pleaded. If there is a right, you must establish how that right accrued to you by your pleadings. And in doing so, give an opportunity to the other side to rebut the claims made by you. Universal principle, Your Lordship.
No, that's fine. That's fine. But then this is not an appeal. This is a review.
I know, yes, Your Lordship. I appreciate that. I appreciate that, Your Lordship. But why I'm raising this point is, Your Lordship, in the first place, the suit, the de novo trial could not have proceeded on the basis of the pleadings filed. That is an error apparent on the face of the record. Secondly, Your Lordship, if evidence which should have been taken into account has not been taken into account, that is also a ground for review. I'll place all those authorities, Your Lordship. I'll place all those authorities. Then, paragraph 28. The statement made by the PWs could not be controverted by the defendant appellants in the cross-examination. So, Your Lordship, this statement is very interesting. This finding of Your Lordship is very interesting. May I elaborate here, Your Lordship? Paragraph 28. The respondents' witnesses, we did not controvert to some extent. My witnesses, they also were not controverted. So the evidence of witnesses on both sides were not controverted, Your Lordship. So in such a scenario, what kind of a decision could the trial court come to? That is the third point I'm trying to make, Your Lordship. That is the third point I'm trying to make. So therefore, relying on only the uncontroverted statements of witnesses on one side, could any decision have been arrived at, Your Lordship? That is the point, Your Lordship. The statements of witnesses on both sides were not controverted. The records are very clear on that, Your Lordship. So how could any decision have been arrived at by the learned trial court, Your Lordship? And also, Your Lordship, may I most respectfully state, Your Lordship, even before this honorable court, during the writ proceedings, the evidence of only one side has been considered. And the evidence of the other side, which is also uncontroverted, has not been taken into consideration. That is the point I'm trying to make, Your Lordship. Then 29. Further, on a consideration of the deposition of DWs, this court is of the considered opinion that none of the DWs have been able to establish that the defendant appellant's village owns fishing right between Surayong Junction to Narepong at the River. This is again, Your Lordship, this is the point where I most respectfully submit, Your Lordship. The uncontroverted statements of my witnesses have been left out. That we also did fishing in this disputed portion. That we deny that the respondent village owns any fishing rights or own any land in this disputed area. That has not been taken into consideration. Uncontroverted. And 30, in the face of unimpeachable statements of PWs. On the flip side, Your Lordship, the unimpeachable statements of the DWs also. This court has no hesitation to come to the conclusion that the respondent plaintiff village and Yachang village are the co-owners having fishing right between Surayong to Narepong at Differ River. In that view of the matter, no further discussion is required in the book of Honorable Customary Law written by Tajanao. Now, the further point, Your Lordship, this is again a point of law, and this has been taken, which Your Lordship has also reflected. Is it possible for anyone, Your Lordship, to sell off a piece of property and then say that the well in the middle of that property still belongs to him? Is it a rational argument, Your Lordship? Is it a rational argument? It is an absolutely irrational argument to say that I own the land, I sold it to him, but I retain the water portion which is in between that land, far removed from my village. Is this a rational argument, Your Lordship? It is not a rational argument, if I may most humbly and respectfully say so, Your Lordship. So these are the points that I'm trying to make in this review application. Evidence, my evidence, which is unimpeached, has not been taken into consideration. Can I take Your Lordship to that evidence?
Yes.
Page number 88 of the paper book, Your Lordship. Yeah, page number 88. Page 88. This is the evidence of PW1. The page 90, Your Lordship, a very interesting statement. Which is at page 19. Where is it? In the middle of the page, Your Lordship, the land located, has Your Lordship got that? The land located between Longchara and Narep belongs to individuals, and by selling it away, fishing rights of plaintiff village located between Surayong and Narep did not extinguish because fishing right between the said portion was acquired by the plaintiff. This is his statement about the fishing rights. Then at page 91, in the cross-examination, Your Lordship, cross-examination, then page 92, page 92. Last sentence, Your Lordship. Has Your Lordship got that? I am not one of the signatories in the Annexure A of the plaint, not making as Exhibit P1. Prime deposition, since my forefathers' time, the land on the bank between Surayong and Narapyong is not belong to our plaintiff. So now, Your Lordship, since our forefathers' time, the land between Surayong and Narap does not belong to our Koya village. So on what basis can it be proved that the land at one point of time belonged to a Koya village? And then it was sold, but the fishing rights retained. Is there any evidence, Your Lordship? This is the plaintiff's own statement. PW1. Since the forefathers, that means if at all they are placing some evidence, their evidence is hearsay. Nothing more. Hearsay evidence. Since the forefathers' time, this land belongs to us, belongs to me, not to them. Then, yes, at page 77, Lordship. This is the position of, where is it? DW1.
Yes.
Page 79. Okay. May I just read the introductory part, Your Lordship? Now I am working as Council Cum Secretary of Chuchu Yimlang. I have been entrusted by the Chairman of the Council for and on behalf of the Council. The present dispute between the plaintiff and the defendants is for fishing right between Surayong Junction to Narab Stream Junction in the river Dikhu. There is no fishing right on the stated portion because the appellant plaintiff has no land on both banks of the disputed portion. In point, so a clear and categorical statement, Your Lordship, and this statement is unimpeached. Then towards the end of the page, the respondent villages was enjoying fishing rights from Yangzuyong stream to Lasong stream for generations together within Dikhu River, being the defendant land was searching within the portion of this Dikhu River. Unimpeached statements, Your Lordship. However, the land ended Lasong to situated between Narap and Lasong stream on the bank of Dikhu River was sold and transferred by one Mr. Suzu Nukshi, Chuchu Himlang, to one Lendi Nogang of Akoya during the recent past generation. Now, Your Lordship, this makes a very interesting point. Within the territories of my village, if I sell land to someone from another village, does that land belong to that village? If someone from Assam buys land in Nagaland, would that portion of land become Nagaland? He owns land within Nagaland. It does not mean that the land bought by him becomes Assam. A very important point of note, Your Lordship. Very important point of note. Past generations. Since then, the fishing right who gone to the plaintiff villager along with the land, thereafter the respondent village is enjoying fishing right from Narab stream upward to Yongzuyong Junction. So again, So we used to enjoy the fishing right up to Lasong. But since we sold Lasong, that portion we have given to them. That portion, that part is not a dispute here. That part is not a dispute. Yes. Yes. And we say, Your Lordship, when we sold the land, we lost the fishing right. That's what we say. So that portion, there's no dispute. That portion, there's no dispute. This portion is different. This portion is where they say they sold the land to us, but they retain the fishing right. Then, thereafter, the respondent villager is enjoying fishing right from Narab stream upward to Yongzung Junction. Yongzung Junction. Okay. Then, page 79 now, my lord. Page 79, the first sentence, Your Lordship, the river Dikhu. Has Your Lordship come to that? The river Dikhu is poisoned for fishing during Mepong Sangar Putu in 1976, between the portion from Langpang Zubon to Narab Stream Junction, and during the Kosa Sangar Putu in 2001. The latest community fishing was done by our village between the portion from Zubu Longzok to Narab Stream. In both the community fishing, I am also present, during which our villagers invited Anja from the following neighboring villages, namely Yajam, Yang, Salu Lemang. That it was during the 2000 last past, our villagers constructed a bamboo platform for fishing around Narab Stream Junction, which was constructed in the wrong place by the youngster. However, it was corrected and reconstructed in the right place. So the point is, Your Lordship, this is clear. These are statements that even our villagers conducted fishing in this so-called disputed portion. So these statements on our side have not been taken into account. And in the last paragraph of this page, Your Lordship, the land between Longchara and Narab on the last bank of the River, bank on the side of the Ao areas, was belonged to Amongshire of Yong village, whereas the said land was offered to Amongshire of Chuchuyungam village by the former during ancestor time and possessed and occupied by the Chuchuyang village of Amongshire and Upper Amongshire as well, but not purchased by Mejongkum from Nongshilimba as alleged by the plaintiff in his affidavit reply. So this is what we are saying, Your Lordship. This land was given to us by the Amongshire of Yong village, and it has been in our possession since then. And it is not land which was purchased by Meja Okum from Nongshilimba. So this statement also remains unimpeached. Yes. Then in the cross-examination, at page 81. Your Lordship, in the cross-examination at page 81, the same witness. Now this is in the cross. I know the facts beginning from that sentence, Your Lordship.
Yes.
I know the facts of the case in 1986. For about 13 generations, we are enjoying, it should be we, it's written well, we are enjoying the water line between Surayong and Narab Stream at Dukku River, which was enjoyed without any obstruction. Then last paragraph, Your Lordship. Akoya says that the water located between Surayong and Narab is jointly owned by Yajam village, which is denied as we are enjoying it with Yajam. This witness denies it completely. Amongshire is survived till date on the bank of Dikhu starting from Narab belongs to Amongshire, belonging to 20 households. The said land is belong to clan, but not belong to village authority. So my evidence that this is not land that we bought from a person from a respondent village, but it was given to us by the Amongshire of Yajam village remains unimpeached. That statement, that evidence, this vital piece of evidence has not been taken into consideration. Then the next. Then DW2, the evidence of DW2 at page 82. 82. And this is a person from Salulemang village. Salulemang village. And the evidence of this witness is important, Your Lordship, because this witness states that he also participated in the fishing along with Chuchu Yimlang in the disputed portion. And this shows that we have been engaging in fishing in the so-called disputed portion all these years. And it is not just them alone. The main examination chief, I am one of the village council members from Salulemang village. Since 1976, I am as one of the members of the council. I know and have attended the community fishing of Chuchu Yimlang village while in our village is Anja. I have attended the said community fishing on 2 occasions. Once in 1976, while the Dikhu River junction was poisoned from Langpang to Narep Stream Junction. The second community fishing in 2001 on 29 January and returned on 30th January, while the Dikhu River portion was poisoned from Subolong to Narep Stream Junction. So this evidence, this witness, an independent witness, so to speak, my lord, an independent witness. This witness clearly states that on 2 occasions, he participated with Chuchu Yimlang village in the so-called disputed portion where the fishing right is claimed. This evidence has also not been taken into consideration. And again, another independent witness at page 83. Yes. And this is from Ungar village. The introduction, Your Lordship. I am one of the Putu Menden members from Ungar village. I belong to the descendants of Among, which is called Amongshir. So, Your Lordship, this is a Putu Menden member, and the importance of a Putu Menden member, Your Lordship will really appreciate. I don't have to explain that, my lord. And the kind of weightage is, not that he is any better than the other witnesses, but this is a responsible citizen. And he says, the descendants of Amongshir of Ungar have a common landed property side the Amongshir of Chuchu Yimlang village. And the said land is called Narep Khedi. Once Sunding Kongdi from Yong village was also one of the descendants of Among Sanchir, who gave the said Narep to the Amongshir of Chuchu Yimlang. So again, Your Lordship, the land on this, which borders the so-called disputed fishing rights portion, was not bought from them. It was given to us by the Amongshir.
It's Naraplu.
Yes, sir. Naraplu. Yes.
The field.
What is that? Yes, the land. So the land was given to us. We did not purchase it from them. Your Lordship. Then at the bottom of the page, Your Lordship, this is also about undertaking fishing in the so-called fishing rights area. It was during winter of 1976. The Chuchu villager invited our villager during community fishing, which called by us as Anja. I was also attended in that year for the same community fishing. The portion of the Dikhu River from Zubolong to Narep Stream Junction was poisoned for fishing, and the platform Nemdang was constructed at the Narep Stream Junction of Dikhu River. Further, it may be stated that Ungar village are used to perform the labor enforced by the government for clearing of the roadside on the portion between Narep Stream and Dikhu River Bridge. This is done by us, being for land. Just go to that. 84, yeah. May I read the cross-examination part, Your Lordship? At page 84. I am working as a Putu Menden member for 23 years. I don't know the year Putu for which a portion of land had given to Amongshir of Sungkangoti from Yong village. One from Amongshir Imdong Zukba received the land. I don't know in which year the land was offered. Some of our father were present during offer of the said land by the Sungkangdi to the Amongshir of Chuchu Yimlang village during the lifetime of Imdong Zukba. The land which was given by Sungding Kangdi is cultivable land, and we're using the said land as per our share. The said portion of land is belonged to Among clans, but not for community land of Chuchu Yimlang. I don't remember the date of the payment of commission, which was from Imsangar clan. The commission money was received by Alambaran between the Dikhu Bridge and the land of Narep Stream for construction of road. That commission was imposed for the construction of the road within the Among land. I am not produced the receipt of the commission for construction of road. I did not appear before the DB's court while the same was case between the same party. No Ungar village is also witnessed in the DB's court. Among Samchir, may now be called Clan Kidong, and survived in Chuchimlang and Ungar. The alleged land said to have been given by Among is jointly owned by Among clan of Chuchimlang and Ungar village, and as such, I am also a Among Samchir. It is a fact that Ungar was regarded and established from Chuchu, and before migrating to Ungar land was already given, but till now I am also a co-owner of said land. As well, our customary land and procedure shall be applied in regard to the landed property. I also attended the community fishing in 1976 on poisoning the water up to Narab. I am at a party in this instant case. So, again, Your Lordship, the evidence of this witness that the land was given within the family from the two villages, unimpeached. The fact that Chuchu Himlang also participated or did fishing in this so-called fishing rights area, unimpeached, but not taken into consideration. Yeah. Then page 86. This is from the person from Yong village. My name is Nokchat of Yong Imchen village, and I am head barik in the village council. I belong to Yong Among Chang clan. My ancestors gave a plot of land to Chuchu Himlang Among Chir village, which is called Nareplu. Naib, the said land, Naib Nareplu was given by ancestor Lua Chang, Esat Jangbe Kuisangba, and Sungti Kongdi to Imdang Lingpa of Among Chang Samchir of Chuchu Himlang village. The said land is bounded as follows: on one side by Duku River, on one side by Bang Jalu, and that side with Marab. I know that the name of the land Bang Chalu, but I can't say the owner who is the owner of this land. It is admitted to whom in the cross, Your Lordship. Now, this is the person who represents the clan from which the land came to me. In the cross, it is admitted that to whom Bang Chalu is belong, that is not known to me at present because it was given during the time of my ancestor. So the fact that the land was given by our relatives from Yong village, not demolished at all, not even questioned. When the person from whose side I inherited the land deposes in court, he is not even questioned on this particular point. This evidence has not been taken into consideration. The story of the deposition that bought the land and acquired the fishing rights, sold the land but retained the fishing rights, nowhere when you compare it with this statement. Then next. So this is the evidence, Your Lordship. This is the evidence. Then there are contradictions in the statements of the plaintiff's witnesses. So a few contradictions, can I place them before Your Lordship? PW1, Lordship, in his examination in chief, he says, at page 89, page 89. Yes, 89. Yeah. Here he says, Your Lordship, in the top portion of the page, in the year 1961, 1966, so and 1991, villages of plaintiff poisoned the Dikru River from Suryong Longzuk to Narab to Memetsuyong. In those community fishing, we have invited by way of Anya the following members: Yong Imseng, Changdongya, Chuching Blang, and Yong Imcheng and Yachang. This is what he says. Yeah. PW6, Your Lordship, at page 98. Keeping this in mind, Your Lordship, PW6 at page 98. Yes. At the last part of his examination in chief, the last paragraph, he mentions the years in the beginning portion, Your Lordship, and the last paragraph of the examination in chief. In that community fishing, the Akoya villages invited Yong Yimson, Changtongya, and Yacham. There is no mention of Chushu Yimlang and Yong Gimsen. At page 89, there is no mention of two other villages, including me. Just one contradiction. Okay. So the point, Your Worship, the point I'm trying to make is this. In passing the judgment which I'm praying for a review, the first point, Your Worship has already noted, insofar as the evidence is concerned, evidence on only one side has been taken into account. Evidence on the other side has not been taken into account. And most importantly, Your Worship, the evidence which remains unimpeached, truly unimpeached, that the land was given to us, not bought from them, that has not been taken into consideration. If that has been taken into consideration, Your Worship, the rational argument that the land also belongs to us, the fishing right also belongs to us, that stands complete. That stands complete. That stands complete. Your Lordship, again, at the cost of repetition, fishing rights cannot exist without ownership of the land. That is a proposition which needs no argument, Your Lordship. To say that fishing rights can exist independent of land, that is an absolutely impermissible proposition. Impermissible in law and in facts. Impermissible in law and in fact. And that is a point which ought to have been taken into consideration also. The fact that the land belongs to me by way of a family settling the same on me, that has not been taken into consideration. One. The fact that we have also been engaging in fishing in this so-called disputed portion, that has also not been taken into consideration. So these are the 2 points emerge. These are the 2 points insofar as this review application is concerned. Now, what does this establish, Your Lordship? What does this establish? The plaintiffs don't own any land between Surayong and Naran. Evidence clearly establishes that. The plaintiffs, now the respondents. The witnesses also very clearly say that the plaintiffs, the respondents, don't own any land between Surayong and Naran. Second, what does the evidence establish? 1 minute. Yes. Second, the evidence establishes that the plaintiffs, respondents, as well as the appellants, defendants, engaged in fishing in the so-called disputed portion. That is very clear, Your Lordship. There is no dispute as far as that is concerned. Both sides engaged in fishing in this disputed area. Yes. Thirdly, Your Lordship, the evidence establishes that the land was given to me by my relatives from Yong village. Unimpeached evidence, Your Lordship. Yes. So this demolishes the ground. This demolishes the entire evidence of the plaintiff's respondents that the land was bought by them, they sold it to us, but they retained the fishing rights. That finding could not have come about on the basis of this unimpeached evidence. Then, Your Lordship, the evidence led all the evidence led, must relate to the pleadings in the plaint. The evidence led cannot go beyond the pleadings in the plaint. And all the pleadings, all the evidence which has been led by the plaintiff respondent is not based on the pleadings in the plaint. Therefore,
Yes.
the trial court could not have come to a finding in favor of the respondent. And also, if I may most respectfully submit, Your Lordship, this honorable court could not have relied on that evidence, to shut out the appellant in this case. That is my case in the review application, Your Lordship. And on this now, Your Lordship, may I place? Yes, Your Lordship. I'm grateful to my engineer for reminding me of this. In addition to the lack of pleadings, once a de novo trial is ordered, Your Lordship, there is a procedure to be followed, a procedure prescribed by law. Pleadings must be filed, the suit must be valued, stamp duty must be paid. Unless these steps are taken in the first instance, the suit cannot be entertained. And that is a requirement of Rule 11. Order 7, Rule 11, Your Lordship. Order 7, Rule 11. Order 7. Firstly, Order 7, Your Lordship. Rule 1.
Rule 1.
Order 7, Rule 1. Particulars to be contained in plaint. The plaint shall contain the following particulars. A, the name of the court in which the suit is brought. B, the name, description, and place of residence of the plaintiff. C, the name, description, and place of residence of the defendant so far as they can be ascertained. D, where the plaintiff or the defendant is a minor or a person of unsound mind, a statement to that effect. E, the facts constituting the cause of action and when it arose. Important, Your Lordship. F, the facts showing the court has jurisdiction. G, the relief which the plaintiff claims. This is a mandatory requirement of law, Your Lordship, because this is on this basis, the other side reacts. Then, Rule 11. Rejection of the plaint. The plaint shall be rejected in the following cases. Where it does not disclose a cause of action. A, Your Lordship, this is the point I was trying to make, where it does not disclose the cause of action. Then B, where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within the time to be fixed by the court, fails to do so. Not to talk of undervalue, Your Lordship, the plaintiff itself has not been valued in the first instance. No stamp duty paid. C, where the relief claim is properly valued, but the plaintiff is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within the time to be fixed by the court, fails to do so. This is something which should have been done as soon as there was an order for a de novo trial. It was incumbent upon the plaintiff to take these necessary steps as prescribed by law. Nothing was done. Nothing was done. Your Lordship will kindly come to the plaint again. The plaint is the appeal filed. The plaintiff did not take any corrective steps. At page 1 of the paper book. Look at the cause slightly, Your Lordship. There is no statement on valuation. No statement at all on valuation. And look at page 7, Your Lordship. No prayers. No prayers. And the pleadings, Your Lordship, beginning from paragraph 2. Beginning from paragraph 2 to paragraph 10. All the evidence of the plaintiff's witnesses, they must be in consonance with the pleadings of, with his pleadings. Not only that, Your Lordship, another point which Your Lordship may note, the Yacham village, who the trial court says is a co-owner along with the plaintiff, not even a party in this case. How do you assign title to a party who's not before court? Declare rights in favor of a party who is not in court? So basically, Your Lordship, they may have a case, they may not have a case, but nothing can be established on the basis of the pleadings filed. Nothing can be established on the basis of the pleadings filed. Nothing can be established. May I take Your Lordship to the authorities now? Your Lordship, I've filed a list of authorities, the citation along with the principal, Your Lordship, so as to save time. A is on pleadings and evidence, and this is 1987 2 SCC, paragraph 6. In the absence of pleadings, evidence, if any, produced by the parties cannot be considered. This is about fundamental principles of law, Your Lordship, of deciding disputes between parties. You must plead your cause of action. You must seek your relief. If you do not plead, any evidence you lead is of no use. It cannot be relied upon, it cannot be considered. 2, 2020 10 SCC 706. In the absence of pleadings, any amount of evidence will not help the party. On the same point, Your Lordship. Then B, review jurisdiction. An error brought to the notice of court is required to be corrected by way of review and not left to a superior court. This would not be a proper functioning of judicial service. So in the handling of this case, Your Lordship, right from the trial court, error upon error, Your Lordship. And we are in this predicament right now. And therefore, Your Lordship, it is a matter which requires to be reviewed. Then 4 is 2005 4 SSC 741, paragraphs 88 to 92. The review application would be maintainable not only upon discovery of a new and important piece of evidence, or where there exists an error apparent on the face of the record, but also if the same is necessitated on account of some mistake or other sufficient reason. Misconception of facts of law by a court or even an advocate can be rectified. Technicalities of law should not stand in the way of administration of justice. Now, Your Lordship, why this is important? Because errors have occurred right from the trial court. Even in the learned trial court, Your Lordship, only one issue was framed. And that is because of the advocate concern, Your Lordship, with all due respect to the person who was engaged at that point of time. But the issue could not have been decided on only one issue. And the next one is 2009 13 SEC 767. A decision on erroneous factual premises is amenable to review. So this is what I'm trying to say, Your Lordship. Erroneous factual premises. Error occurred, Your Lordship, in the first instance at a trial court level. The second, Your Lordship, before this honorable court, when only one side, the evidence of only one side was taken into consideration. The evidence on the other side was not taken into consideration. And the unimpeachable evidence, Your Lordship, to the effect that the land was given to me, I did not purchase it from him. And in fact, if that evidence was taken into consideration, the entire case of the respondent falls. And that is evidence which was there before this honorable court, Your Lordship. Then 6, section 114 of CPC provides for power of review by a civil court and consequently by the appellate courts. So earlier, when the review application was filed, the court at that point of time wanted me to clarify as to whether an appellate order could be reviewed. So this is a decision on that point. Then, next page, Your Lordship. 2010, 5 GLT 52, paragraph 6. This is by own High Court. It is the duty of the court to rectify, revise, and recall its orders if such orders have been passed on wrong and mistaken assumption of facts. This would be a case of an error or mistake apparent on the face of the record. So mistaken appreciation of facts, Your Lordship. Then 8 is 2011, 12 SEC 172, paragraph 6. Failure to take into consideration material evidence which is present on the record would amount to mistake apparent on the face of the record. So this is the point I was trying to make, Your Lordship. Evidence on one side taken into account, evidence on the other side not taken into account. So that constitutes a mistake apparent on the face of the record, and it is ground for review. Then the last, this is a very interesting case, Your Lordship. This is 2019 4 SEC, where a suit is filed for improper reliefs and the evidence led is incapable of settling the list between the parties. Parties may be granted the liberties to file fresh suit with proper reliefs. Earlier proceeding on improperly sought reliefs not to operate as res judicata. So on the last ground, Your Lordship, if at all this Honorable Court reviews as prayed for and comes to the conclusion that the list between the parties is not resolved, looks at the pleadings filed by the parties and sees that there are no proper pleadings, no cause of action actually, Your Lordship. There is a way, and this is the way as decided by the Honorable Supreme Court. In short, Your Lordship, that is my case. So may I humbly submit, Your Lordship, that as far as the review applicant is concerned, it is our respectful submission that there is ground for review of the order before this Honorable Court, and that in the interest of justice, and not only interest of justice, but in the interest of both the parties also, the matter should be remanded back to the learned trial court. That is my case, Your Lordship. Pick up at 2. Just 5 minutes. In fact, Your Lordship, there are 2 ways open. Forgive me for sounding presumptuous. If my Lord has the mind to remand the matter back under Order 41, there is provision to remand with issues which the Honorable Court may think that the trial court needs to go into. May I just file a sample copy, Your Lordship? I can give you a copy. Of course, if Your Lordship decides that the entire matter be tried afresh again in terms of the decision of the Supreme Court, and that's a different issue again.